and you know you're hearing something, and you listen, you'll lean forward. And so it's our great privilege that Colonel John Eidsmoe is with us. I should say, I call him Colonel. He's a retired lieutenant colonel in the Air Force, and just a spectacular man. So take it away. A lot of pressure.
It's a great joy to be with you here, and this Sunday is September 17th, Constitution Day. This is Constitution Weekend, as I would put it, and I can't think of a better place to spend Constitution Weekend than with Phyllis Schlafly's Eagles. We just heard a remarkable address here by Mark, and I'm so impressed by everything you've been through. To tell things in the first person like he did, I was kind of thinking maybe I could revise my presentation a little bit with all my white hair. Maybe I could convince you I was at the Constitutional Convention and that I knew Washington and these other people personally, but I didn't. But I have studied their works extensively, and I think I can share with you some of what they tried to get across and what they tried to leave with us. In Psalm 11, verse 3, we read, "If the foundations be destroyed, what can the righteous do?" If the foundations be destroyed, what can the righteous do? The basic foundation of this nation, the moral foundation, is the Bible. The political foundation is the Constitution, which is based on biblical principles. And those foundations are being destroyed in America today. The Constitution was drafted at a convention 236 years ago. It was ratified and has governed us for now 234 years. But first question I'd ask is, what is a Constitution? It is a law, but more than a law, it is the supreme law of the land. And as the supreme law of the land, that means it is above other laws. In this sense, first of all, it is the authority for all other laws. Other laws are valid to the extent that they are authorized by the Constitution. And second, it is the standard by which other laws are interpreted and even measured as to their validity. I'm going to suggest to you that our Constitution is a Christian document, and I would agree with Ed completely that there are some, like Ramaswamy, who may not be Christians themselves, but understand the Christian foundations of this nation far better than a lot of Christians do. But it was written as a Christian document. In fact, if you look to the delegates to the convention, there were a few who would not be considered Christian in an orthodox sense of the word, but the vast majority were. If you look to those 55 delegates, we find that 28 of them were members of the Church of England, which was an Orthodox church in those days. 8 were Presbyterians. 7 were Congregationalists. That's mostly the New England Puritans. There were 2 Dutch Reformed, 2 Lutherans. That might have been the Missouri delegation, although I don't think they made it. There were 2 Methodists, 2 Roman Catholics, 1 whose religious preference we don't know, McClurg of Virginia, probably an Episcopalian because he's buried in an Episcopal churchyard, but he didn't write anything about it that we know of. That leaves 3, or about 6%, who you might call unorthodox in their religious beliefs. If you look to where they got their ideas, there were a couple of political science professors, Donald Lutz and Charles Heinemann, back in the 1980s, who did some research, studied thousands of documents of leading American figures from 1760 to 1805 to identify quotations, see who they were quoting, where they got their ideas, what authorities they respected. He found that about 34% of all quotations in the Founding Fathers' writings were taken from the Bible. Of the others that were not taken from the Bible, he found that the most common was from Baron Montesquieu of France, a devout Roman Catholic. Just behind him was Sir William Blackstone of England, a devout Anglican. And third would be John Locke, not totally Orthodox, but basically within the Christian camp. And if you look at a few examples of some of their Christian profession, I'll just mention a few of them for you here. A couple of my favorites, for example, Alexander Hamilton. Hamilton might surprise you that shortly before he died, he laid plans to establish an organization that he thought could preserve what was necessary for this nation, and he wanted to call it the Christian Constitutional Society. Doesn't sound exactly like Americans united for separation of church and state, does it? And of course, his plans were cut short by a duel, and the night before the duel, he wrote to his wife that as a Christian, he couldn't really return fire in a duel, and so he had only one choice available to him, and that was to face Burr in the duel and refuse to shoot back. And he wrote to his wife the night before the duel and wrote to several other people similar letters, but he wrote, "The scruples of a Christian have determined me to expose my own life to any extent, rather than subject myself to the guilt of taking another. This much increases my hazards and redoubles my pangs for you, but you would rather I should die innocent than live guilty. Heaven can preserve me, and I humbly hope will, but in the contrary event, I charge you to remember that you are a Christian. God's will be done. The will of a merciful God must be good. Once more, adieu, my darling, darling wife, Alexander Hamilton." The next morning, he faced Burr in the duel, and not quite clear what happened because it was all in a split second, but seemed clear Burr fired first, Hamilton was struck, his pistol fired, but probably just reflexive clenching on the trigger, and the shot went wild. He lingered on for some 31 hours. Shortly before he died, he took communion, and he declared on his deathbed, "I have a tender reliance on the mercy of the Almighty through the merits of the Lord Jesus Christ." I'll give you another, John Jay. John Jay was one of the authors of the Federalist Papers, along with Hamilton and Madison. He was the first Chief Justice of the United States Supreme Court, negotiator of Jay's treaty with England, and they chose him because the treaty was going to be called Jay's Treaty, so they thought, no, the other way around. But anyway, he was also president and a founder of the American Bible Society. He wrote, for example, in an address to the American Bible Society, his views of the message of Scripture and the need to convey Scripture to people who don't have it. By conveying the Bible to people thus circumstanced, we certainly do them a most interesting act of kindness. We thereby enable them to learn that man was originally created and placed in a state of happiness, but becoming disobedient was subjected to the degradation and evils which he and his posterity have since experienced. The Bible will also inform them that our gracious Creator has provided for us a Redeemer in whom all the nations of the earth should be blessed, that this Redeemer has made atonement for the sins of the whole world, and thereby reconciling the divine justice with the divine mercy, has opened a way for our redemption and salvation, and that these benefits are the free gift of God, not of our deserving, nor in our power to deserve. He describes, well, he was an ambassador to France, of dealing with some of the French deists and philosophes there. He just simply says, "During my residence there, I recall 2 conversations with atheists about their tenets. I was at a large party of which were several of that description. They spoke freely and contemptuously of religion. I took no part in the discussion. In the course of it, one of them asked me if I believed in Christ. I answered that I did and that I thanked God that I did. Nothing further passed between them and me or any of them on that subject." I go on to George Washington, and Washington was not outspoken about his views, and some of us might think about that when we wonder whether 50 years from now our children or grandchildren will remember whether we were Christians. If we were charged with being Christians, would there be enough evidence to convict us? But Jared Sparks, who was the chief biographer of Washington in his 12-volume collection of Washington's writings, he says, "A Christian in faith and practice, he was habitually devout. His reverence for religion was seen in his example, his public communications, and his private writings. He uniformly ascribed his successes to the beneficent agency of the Supreme Being, charitable and humane. He was liberal to the poor and kind to those in distress. As a husband, son, and brother, he was tender and affectionate. If a man spoke, wrote, and acted as a Christian through a long life, who gave numerous proofs of his being himself to be such, and who was never known to say, write, or do a thing contrary to his professions, if such a man is not to be ranked among the believers of Christianity, it would be impossible to establish the point by any train of reasoning. The one argument that people commonly make when they try to suggest that Washington was not a Christian was they will tell you he didn't take communion. Is that true, that he didn't take communion? Well, let's look at the facts. First of all, before the war began, he took communion in the Anglican Church. After the war, he took communion in the Anglican Church. During the war, he took communion in other churches, but not in the Anglican Church. Can anybody figure out why maybe he wouldn't take communion in the Anglican Church during the war? Who was the head of the Anglican or Church of England? King George III. How can you say he's in good standing with the Anglican Church when he's conducting a war against King George III? Somebody who was less conscientious probably would have neglected that point, but that was his reason. Washington, when he became a vestryman in the Church of England, he signed a sworn oath saying that he accepted the doctrines of the church, which included the authority of Scripture, the Trinity, the divine and human natures of Jesus Christ, the substitutionary atonement of Christ on the cross, and justification by grace through faith. If Washington was a deist, he committed perjury in signing that oath. I've made this offer many times in speeches, ever since writing this book, Christianity and the Constitution, $1,000 to anybody who can produce any authentic statement of George Washington in which he either claims to be a deist or in which he denies any fundamental doctrine of the Christian faith. I've been making that offer now for 30-some years. I still have my $1,000. Those are just a few. I could talk about so many other of the Founding Fathers, but let's go on to look at the purpose of the Constitution. It is to give government power, but also to restrain that power. And the framers of the Constitution, as they put that document together, came together with two views very much in common. First of these would be a high view of God and His law. Just like Jefferson says in the Declaration of Independence, that we are entitled to our independence by the laws of nature and of nature's God. But secondly, a low view of man and his nature. They didn't believe, like those of the French Revolution, that human nature is good or that man is perfectible. They knew that he is, as the Bible describes him, a sinner and as self-interested, corruptible. And so they needed to put together a document which would give government enough power to govern effectively, because they knew that government has to restrain sin. But they were concerned about the other aspect too, the sinful nature of man, because they knew that those who run the government have the same sinful nature as everybody else. I think the Houck family has come to see the truth of that, haven't you? The doctrine of original sin is a great leveler. And so how do we give government enough power to govern effectively, but restrain that power so government does not become tyrannical and oppressive? James Madison, who had studied at the College of New Jersey, it's changed its name recently to something like Princeton or something, but anyway, he wrote in Federalist number 51 that what is government but the greatest of all reflections on human nature? He says if men were angels, no government would be necessary. In other words, if people were good, we wouldn't need government. If angels were to govern men, neither internal nor external controls on government would be necessary. In other words, even if men are evil, if we still have a few wise, benevolent philosopher kings, we can simply give them absolute power and they'll wield in everybody's best interest. But Madison is suggesting our rulers aren't angels either. And so he says, in framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself. I love the way Daniel Webster put it, because, we've seen this COVID crisis and so on. Maybe I'm naive, but I will concede that many of those who pushed for these regulations, at least in first, honestly believed that they were trying to help people and save us from an epidemic. But like Webster says, good intentions will always be pleaded for every assumption of power, but they cannot justify it. It is hardly too strong to say that the Constitution was made to guard the people against the dangers of good intentions. So how did the Founding Fathers solve this problem? They solved it with what I'm going to call the Founding Fathers' five-fold formula for freedom. In seminary, they teach you how to do alliteration, but I'll just add a corollary to that. Alliterations are almost always absolutely awful. But let's look at this five-fold formula. First, government of limited, delegated powers. That is, government has only the power that we, the people, have delegated to it through the Constitution, and no other. That's a biblical principle. Deuteronomy 17, for example, where we see the prophetic reference to a king over Israel. God says through Moses that when they have their king, they can still have a system of limited government if they limit the power of the king. That he is not to elevate himself above the people, he is to simply be one of the people. That he is not to take multiple wives to himself, as Solomon does and is corrupted by it. That he is not to multiply gold or silver to himself, that he is not to multiply horses, by that we mean large armies, to himself, and so on. And the king is to write annually the law of Moses in the presence of the priests. In this way, government is to be limited. If any government official comes to you and says, "Show me where the Constitution says I can't do this," he's got it all turned around. He has to show where the Constitution says he can do something, or he doesn't have that power. And just to make sure that down here in the 21st century, somebody didn't get that mixed up, they put it in concrete in the 10th Amendment, where they said that the powers not delegated by this Constitution to the United States, that is federal government, nor prohibited by it to the states, are reserved to the states respectively, or to the people. That is the cornerstone of limited government. Second principle would be separation of powers. We look to the Constitution, and we see that legislative power is primarily in Article 1, executive power primarily in Article 2, judicial power primarily in Article 3. Look to Isaiah 33:22. The Lord is our judge, the Lord is our lawgiver, the Lord is our king. He will save us. All three branches of government, all put together right there in one verse in Isaiah. The idea is that no one branch, no one level of government is to gain too much power. Third, checks and balances among these branches and levels of government. In 2 Chronicles 10, verses 3 through 5, we see where the northern tribes come to Rehoboam and ask him to give them tax relief and relief from the mandatory work details and so on. He refuses. The result is their secession into the Northern Confederacy and so on. But you consider what is happening here. They are interposing and checking and balancing on behalf of their people against the federal king. But the idea that we don't just have three branches and three levels of government, they check one another. The president Congress can pass laws. The president can veto those laws. Congress can override that veto by a 2/3 vote of both houses of Congress. The court has the power to strike laws down as unconstitutional, but the justices and all federal judges are nominated by someone in the executive branch and confirmed by the Senate and the legislative branch. So we see checks and balances back and forth. Reserved individual rights is the fourth part of the formula. One good example of individual rights that we see in the Bible is way back in 1 Kings chapter 21, where we see King Ahab. And you remember King Ahab may have been a believer, but a pretty weak believer, and married to the wickedest woman in the entire Bible, although her daughter Athaliah would give her a good run for her money on that. But she is a Phoenician princess, and she's used to Phoenician law, not biblical law. But you recall that Ahab wants Naboth's vineyard, and he seeks to buy the vineyard. Naboth says, nope, not for sale. It came from my ancestors. I'm passing it to my descendants, not for sale at any price. And so Ahab goes back to the palace dejected, because as weak as he was, he at least knew that under Israelite law, if Naboth wouldn't sell in the vineyard, Naboth had a right to refuse the sale. Well, you recall what Jezebel does, and she says, I'll get you that vineyard Phoenician style, and she has Naboth brought in under false charges and executed and property forfeited to the government. And of course, Elijah then says, because of this, that both of them are going to lose their lives, and they do. But individual rights, rights that are guaranteed by the Constitution, rights that even a majority of the people, even concurrence of two branches of the government, may not take away. The right to free exercise of religion, the right to freedom of speech, the right to keep and bear arms, which Justice Story in his commentaries on the Constitution said is the outer parameter, the outer palladium or outer wall protecting liberty. Some say that the right to keep and bear arms is the right that makes all the others possible. I've heard it put this way, that if I had a choice between the right of free speech and the right to keep and bear arms, I'd choose the right to keep and bear arms. And then I can say whatever I want because I have a gun. There's a congressman in Texas who had a bumper sticker, and I have this over my door at the foundation office. It says, if babies had guns, they wouldn't be aborted. So maybe that's our next campaign here, that every baby be armed. And the final part, look at this formula again: limited delegated powers, separation of powers, checks and balances, reserved individual rights, responsibility through religion. The framers didn't want a state church, and neither do I. Do you think I want Joe Biden heading the church? Certainly not. But they knew that besides saving souls for eternity, religion also plays the role of developing with people the kind of moral character that makes responsible self-government possible. Gouverneur Morris, a founding father who was far more influential than most people realize today, he served as an ambassador to France, and he wrote that the French people, the American Constitution would not work in France because he said the French people lack the moral character for responsible self-government. But in America, things were different because of our Christian base. In his farewell address, Washington said, of all the dispositions and habits that lead to political prosperity, religion and morality are indispensable supports. John Adams, our second president, possibly the greatest scholar ever to sit in the White House, put it this way: our Constitution was made only for a moral and religious people. It is wholly inadequate for any other. So putting that formula together, that's what the Constitution is all about. We have seen the foundations being destroyed in America, and it didn't just start recently. We can go back into the late 1800s, where we see a move under the influence of Darwinian thought to getting away from the plain interpretation of the Constitution as intended by the framers and moving instead toward a Darwinian view of the Constitution, that it changes with time. We call it the living Constitution, that every generation should be able to reinterpret for itself. A living constitution is the same as no constitution at all. Because what it really means is a silly, putty constitution that any judge can mold to mean whatever he wants it to mean. And with this living constitution approach, we see judges reading their own ideas into the Constitution and claiming there is a right of privacy that includes the right to abortion and things like that, and ultimately same-sex marriage, or that there are powers in the Constitution that are far, far afield from anything the framers developed as they spoke about the commerce power or the general welfare power and so on. These are being stretched way beyond recognition to give the president and the Congress the power to do just about anything they want to in these areas. So the living Constitution is very dangerous. It removes the Constitution from any kind of objective scholarship, and it gives judges unlimited power. I'm reminded of the words of Humpty Dumpty there in Through the Looking Glass, where he and Alice have this discussion, and Humpty Dumpty says, "When I use a word, it means whatever I want it to mean, nothing more and nothing less." And Alice says, "The question is, can you make words mean different things?" Humpty Dumpty answers, "The question is, who is to be master, that is all." And he's right. If judges can make the words of the Constitution mean what they want them to mean, then judges have become our masters. And that is not the frame of government that our founders gave us, nor is it the form of government that I think most of us want today. Fortunately, we have a Supreme Court today, largely due to the influence of Donald Trump, and I might say that his judicial appointees not only have changed the Supreme Court, but have changed the federal judiciary as a whole. Some of his appointments at the circuit courts of appeals and the federal district courts have been marvelous appointments and are writing some wonderful decisions. But they are bringing the Constitution back to what the framers intended. We look at Dobbs versus Jackson, for example, the decision that overruled Roe versus Wade. Actually, it's a moderate decision. They could have done one of three things. They could have gone to one extreme and said that Roe versus Wade is right. The Constitution guarantees a right to abortion, and therefore abortion must be legal in all 50 states. Or they could have gone to the other extreme and said the guarantee of liberty in the 14th Amendment includes the right to life for unborn children, and therefore abortion must be illegal in all 50 states. Instead, they took a middle ground approach. And they simply said the Constitution does not guarantee a right to abortion, and it is not deeply rooted in our history and tradition. Therefore, it is up to the states to decide whether abortion should be legal or illegal, or what restrictions should be placed upon it, which means that that's where the battle is taking place today. And we've seen a few plebiscites and so on that have not been to our liking. But that just means that we have our work cut out for us in convincing the American people that life begins at conception and the unborn child is entitled to that protection. The court has really made some remarkable changes in the area of religious liberty. And I'm going to just set out my watch here so I see where I am on time. I'll do my best to end on time here, or Ed will end it for me, I am sure. By the way, you heard about the father who once said to his son as they're sitting in church, "You know what it means when the pastor takes off his watch and sets it on the pulpit?" "No, what?" "Absolutely nothing." But I'll do my best to follow it. But back in the 1960s and 70s, the days of the Warren Court, for example, the court seemed to have a hostility toward religion, a hostility that was reflected in decisions that seemed to make religion suspect. You could have all kinds of other things going on in the schools, but prayer was virtually forbidden by the Engel versus Vitale decision of 52. You could have posters all over the place advocating all sorts of things, but the Ten Commandments, in a 5-4 decision in 1980, Stone versus Graham, the court said you can't have the Ten Commandments in public schools today. I don't think that decision would be the same if it were relitigated today, but that was the decision then. Starting in the 1980s, the court began to move a little bit away from that radical hostility approach toward an approach that gave religion an equal place, the idea of equal access. If you're going to have other organizations meeting on school grounds, you've got to allow Youth for Christ and religious groups to meet as well. Just within the 2022 court term, we saw some very fine decisions in that regard. For example, Shurtleff versus Boston, where the Supreme Court, and interestingly enough, this was written by Justice Breyer, and it was a unanimous decision, but the case involved a pastor and an organization, his church, that would have a Constitution camp at the city park there in Boston, and they wanted to fly their church flag with the cross on it while they were having that event. Now, at first glance, you might think, flying a church flag in a city park, that seems like an establishment of religion. But when you look at it more, the regular practice was that other organizations, when they had activities in the park, were allowed to fly their flags. In fact, in the last few years, over 300 organizations had been allowed to fly their flags, including communist organizations and gay pride organizations. This was the first time any organization had been denied. The Supreme Court said that so long as other organizations are allowed to fly their flags, it isn't an establishment of religion to allow this church to have theirs when they have an activity. And so they said it's not an Establishment Clause violation. Rather, by not allowing this, you are violating their free speech and their free exercise. Equal access for religion. Carson versus Macon, a decision that came out of a practice of the state of Maine. Maine has a lot more wilderness area than a lot of us down in this part of the country would realize, and as a result, there are some parts of Maine where it is impractical to build public schools, so they would subsidize parents in sending their children to private schools, so long as they were secular private schools. Religious private schools, no, then you got to do it on your own nickel. Well, the Supreme Court in a 6-3 decision ruled in favor of Carson, saying that that is unconstitutional. You don't have to subsidize anybody sending your children to private schools, but if you're going to do that, you can't discriminate against religious private schools. And likewise, the Coach Kennedy case out of Washington State, Kennedy versus Bremerton, where Coach Kennedy, as you recall, had a practice of going out on the 50-yard line at the close of a game and kneeling in silent prayer. After he did this a couple of times, some of his players asked, could we join you? And he said, it's a free country, you can do whatever you want. And then players from the opposite team wanted to join and were allowed to, people from the stands as well. And then the school district said, can't allow this, establishment of religion. And you can do anything else you want. If you want to go out and tell jokes, you can do that. If you want to quote Shakespeare, you can do that. But no prayers or religious speeches during or after the game. Well, again, the Supreme Court ruled in favor of Coach Kennedy, and so we've seen some very good victories there, giving equal access and equal treatment for religion. But now in the last term that just ended last June, the 2023 term, we've seen a couple of decisions that have gone even a little step beyond that. Accommodation decisions, where, for example, in 303 Creative versus Alenus, where there you're pitting the religious rights of those who have this website, a website that they are developing where they produce videos of people's weddings for them with a Christian theme to those weddings, and a gay couple wants a video of their wedding and they say we can't do it. Not that they refuse to serve gays, they serve gays regularly, but we're not going to create a gay message. Because the First Amendment not only means that you can't be prohibited from saying what you want to say, it also means you can't be forced to say what you don't want to say. And so we are pitting in this case their free speech and free exercise right to refuse to convey a message they don't want to convey versus the right, which is not found in the Constitution, to have gay marriage. The Supreme Court, after messing around on this for quite a number of years, finally ruled clearly in this case in favor of the right of free speech and free exercise. And so even though somebody else might be required to create a gay video, People with sincere religious objections are entitled to an exemption. And likewise, the case of Groff versus DeJoy, this is a case involving a postal worker. By the way, at the foundation, every one of these cases that I mentioned more recently here, we filed amicus briefs in support of the parties in these cases, and we will continue to do so. And Judge Moore certainly appreciates the support that you've given to him throughout his career, Ed, and we thank you very much on that. But anyway, in Washington, D.C., there was a postal worker, Groff, who had objections to working on Sunday, and for years that was never a problem, until the mail service a few years ago decided we're going to start Sunday deliveries. I didn't put this in our brief, but I thought about saying that we wish that instead of Sunday delivery, they'd concentrate on a little better service during the week. But at any rate, they fired him because he would not work on Sunday, and he said that he was entitled to an accommodation based on the Civil Rights Act of 1964, as well as the Free Exercise Clause of the First Amendment, and the Supreme Court ruled in his favor. They said that under the Civil Rights Act, you have to be accommodated for your religious practice unless that accommodation would impose an undue hardship on the employer. And they said that hardship has to be a genuine hardship, not mere inconvenience. And so, excellent decision. And showing, again, accommodation. In other words, removing from hostility to neutrality to equality to accommodation. Now we have another case that I'm going to tell you about, and that is one that the foundation has been handling for the last several years. It involves a pastor, Pastor Tony Spell, pastors a large 2,000-member church in Louisiana, and Governor John Bell Edwards had issued an order that because of COVID, no churches may meet with more than 10 people in attendance. As I say, he has more than 2,000, and he said, I must obey God rather than man based on Acts 5:29. Well, he was arrested for this. He was subject to several misdemeanor charges. The Louisiana Supreme Court threw all the charges out. They said, look, you're not limiting Walmart to 10 shoppers, so you can't discriminate against the church by limiting them to 10 worshipers. But we decided we wanted to take this a step further. That was a victory. But we wanted to go a step further, saying that he's entitled to more. And so we have a petition before the U.S. Supreme Court, and I'm very thankful that we've got 3 very fine amicus briefs, including one from Andy Schlafly on the part of the Eagles here. We thank you so much for that. Andy wrote an excellent brief for us. But what we are arguing is that, as you've said in previous decisions, you need to get back to the intent of the framers. The intent of the framers is based upon the Reformation, and the Reformation idea of 2 kingdoms, church and state, which goes back to Augustine. In fact, Augustine's work, The City of God, where he talks about these 2 kingdoms, church and state, that Luther said that Augustine's work set the course of Western civilization. But the idea really goes back to ancient Israel, where in ancient Israel, you see 2 kingdoms, church and state. Separation of church and state was practiced there probably better than in any other society. You see the kings of Israel always coming out of the tribe of Judah, the priests coming out of the tribe of Levi. Much more that I could go into there, but my time is running out. And so what we are arguing is that when you look to the intent of the framers, you need to look to the concept of 2 kingdoms. These are separate jurisdictions. Jefferson, for example, as in his second inaugural address, he says, in matters of religion, I have considered that its free exercise is placed by the Constitution independent of the powers of the general government. Separate jurisdictions. Madison, in his memorial and remonstrance against religious assessments, which many take as being an anti-Christian document, he argues against these assessments for very different reasons, what are commonly given. First of all, he says, if we are going to be giving a subsidy to Christian pastors, we're going to have to determine who is and isn't a Christian pastor. And he asks, would Socinians, in other words, Unitarians, be considered Christian? Would Quakers be considered Christian, and so on? And he's saying the government is going to have to make that determination if we enact this subsidy, and the government has neither the competence nor the jurisdiction to do so. And he goes on to say that the Christian religion we believe to be of divine origin, and therefore it does not need the aid of the state. I would add it doesn't need the hostility of the state either, which is what it's getting today. But that's the concept of the framers, separate jurisdictions, church and state. And so I put it this way. Let's suppose that Pastor Spill had issued an order saying that all state offices in Louisiana have to close. People would stare in wide-eyed amazement. Where do you get authority to do that? Our point is this. Governor Edwards has no more authority to close churches than Pastor Spill has to close state offices. Well, this is coming up for a conference in the Supreme Court. They set it for conference for September 26th. And I understand they only set a case for conference if at least one justice says, we need to discuss this one. Then, if 4 justices vote to hear the case, they will grant certiorari. It'll be full briefing and argument and so on. Plain fact of the matter is less than 1% of all cases are accepted. So mathematically, the odds are against us, and it's a new argument, but at least it's a way of getting the argument before the court. That's what we're doing today, and I have till, what, about 2 more minutes? Sure. 2 or 3 more minutes for questions, and I'm going to give you a threat. My threat to you is that if you don't ask some questions for the next 3 minutes, I'm going to tell dad jokes. I made that threat to my kids, that's why they're not here. But
Go to this mic if you have a question, so it's on the sound for the recording.
Okay, first dad jokes. Why was it that when go ahead. Okay, I'll save that one. I think it's on.
He'll repeat it. Go ahead.
Testing. Oh, there we go. Okay. So great presentation. Thank you so much.
So was yours.
Appreciate that. We'll talk later. 17 enumerated responsibilities of a congressman. How come most congressmen and women ignore these enumerated responsibilities in the Constitution and they don't vote with the Constitution, but all this other stuff that has nothing to do with the Constitution? How has that come to be? What happened that created this situation whereby most legislators aren't paying attention to the Constitution?
Okay, the question is asked here, with the powers that are enumerated in Article 1, Section 8 of the Constitution, why is it that it seems like Congress is ignoring these today? Well, first of all, I suspect that in most cases when congressmen are considering whether to vote yes or no on a certain bill, they don't even consider the question of constitutionality. And there are some who would say, we'll leave that to the courts to decide later, but no, all 3 branches have a duty to look to the Constitution and to evaluate it. I thought Andrew Jackson, when he vetoed the National Bank in 1832, I thought his veto message there was a classic, and whether you agree with the National Bank or not, where he says that every one of us takes an oath to interpret the Constitution as he understands it and not as somebody else understands it. But anyway, that's one thing, is that sometimes they just ignore it. Secondly, they follow this living Constitution approach that we can read into the Constitution all kinds of new ideas. Thirdly, they take just a few key provisions of the Constitution and give it very expansive interpretations. One of those being the general welfare clause, that Congress can tax and spend for the general welfare. They fail to realize that that's limited by taxing and spending first and by the 17 articles that follow after that. But it also says general welfare. It doesn't just say welfare, it says general welfare, and general is placed there as a limitation. It means it has to be for the general welfare, not for the specific welfare of some region or some identity group. Another one that they wildly misinterpret is the Commerce Clause, which applies only to interstate commerce, but they have gradually stretched that to say anything that has any substantial effect on interstate commerce can be regulated. And then the Necessary and Proper Clause of the 13th or the 18th clause there, the Necessary and Proper Clause would be another one that I would argue that they have greatly misinterpreted. And just to summarize real quickly on that, I would say that they paid way too much attention there to what is necessary and not nearly enough attention to what is proper. But that's just a start. But go ahead.
It seems like we've lost so much ground from the courts. Is there an opportunity to take those things back that we've lost?
Okay, the question is, we've lost a lot of ground with the courts. Is there an opportunity to take those things back? I'd like to believe that that is what the court is doing right now, not just the Supreme Court, but other federal courts as well, that when they're being accused of being activists today, all they're doing is undoing the activism that has been done for the last 100 years. So I think it is being done. But on the local level, of course, we need to be careful that those whom we vote for, those whom we elect to office, be people that will adhere to the Constitution. And I'd just say that Democrats have a horrible platform and they follow it. Republicans have a pretty good platform and they follow it some of the time. But in other words, we can't just assume that a Republican is going to be a constitutionalist. We have to hold their feet to the fire too. But also support organizations like the Federalist Society and others that are battling in law school campuses and so on to stand for principles of original intent with the Constitution and the like. Organizations like Alliance Defending Freedom, our own Foundation for Moral Law, and the Defense Fund that Eagle Forum here has established. These groups need your support. Encourage people to go to law school. And there are some good Christian law schools like the Oak Brook College of Law in California, where I do distance learning teaching, or the Liberty Law School at Liberty University and Regent Law School at Regent University. So, and Ave Maria in Florida, or Brigham Young in Utah. There are a number of law schools that are pretty conservative, and they deserve your support. And encourage, if you know somebody that's interested in law school, encourage them to go.
I'm going to encourage you to go.
Okay. Good answer.